I'd like to start by acknowledging the traditional custodians of the land on which we meet today, the Gadigal people, and extend my respects to elders past, present and emerging, and also extend that respect to any Aboriginal and Torres Strait Islander colleagues with us today. So welcome to today's session, where we'll be deep diving into the intersection of legal capability and legal need. I've got the great pleasure of introducing to you Professor Nigel Balmer, who is the Research Director of the Victorian Legal Services Board and the former Research Director of the Victoria Law Foundation. And we've got here with us today Dr. Hugh McDonald as well, who is the current Research Director of the Victoria Law Foundation. So Nigel and Hugh will be taking us through the key findings of volumes 2 and 3 of the Public Understanding of Law survey. And after that, we'll have a Q&A panel moderated by our Research Director, Kate Davies. We welcome you to put through any questions you may have through Mentimeter. There's a QR code there for you to use. We will pop it back up during the Q&A session, but if you want to pop it open now, you can put through some questions as we go. And without further ado, I will hand over to you, Nigel and Hugh. Thank you.
Thanks very much, Ollie. It's me. We'll start. I'd just like to pay my respects to the traditional custodians of country where we meet, the Gadigal people of the Eora Nation. Pay my respects to their elders, both past, present, and extend my respects to any First Nations people in attendance. What's the public understanding of law survey? Well, it's a legal needs survey. It's a legal capability survey. It's a face-to-face survey for 6,008 Victorians. It taps into their actual lived experiences of justiciable problems, and it provides statistically representative findings for Victoria. A big question we get asked quite often, does it apply to the rest of the country? Probably. We don't have any reason not to believe that it would. But of course, it's a diverse country and we can't know for sure. So we would need a new national legal needs survey to know for sure. Just a real quick recap on PULS 1. Like the law survey, demonstrated really strong patterning of justiciable problem experiences by problem and people characteristics. We see strong drivers of inequality in that experience. PULS provided updated data on legal needs and really critical new important findings, both on legal problem duration and also on whether legal need was met or unmet. Nigel will go into more about that later. Critically, it found that civil legal need, certainly in Victoria, it's the norm. It's not the exception. So we found really high rates of both legal problem experience and having those needs unmet. In short, this is a spoiler. This is giving away Nigel's entire presentation. Legal capability, it really matters. It's a real thing. I mean, I've been talking about legal capability with many people in this room for more than 10 years. Previously, we did that from a conceptual basis. We'd sort of extracted what we could out of the data and the research that we had available at the time. But now we have a much stronger empirical finding than ever before. And we see this as being a real step change in the empirical understanding and work. So we see unequal distribution of capability. There are links to disadvantage, but importantly, it's not all about disadvantage. And it really provides another layer of inequality in access to justice. Better understanding of legal capability can help particularly shape service provision to better meet the diverse needs across the community and potentially optimise and the use of resources and improve outcomes. But just really quickly, what is legal capability? Well, the definition we've run with is the freedom and ability to navigate and utilise legal frameworks which regulate social behaviour and to achieve a fair resolution of justiciable issues. It really is the characteristics or competencies necessary to resolve legal problems effectively. That comes from the Law Survey. And even back when we did reshaping legal assistance in 2014, we were talking about, and we'd recognise that the term was widely used to refer to an array of knowledge, skills and attributes required for an individual to an effective opportunity to make a real informed decision about whether or not to make use of the justice system. So legal capability really goes hand in hand with knowing that the law is available to you and that it may offer a solution, and it might offer a solution to you that you want to take up and use. Importantly, legal capability is multi-dimensional. There's multi-aspects to it. So it's not just all about knowledge. Previously, when we sort of spoke about legal literacy, it's very much focused on knowledge of the law. But through the empirical research, we had an idea that it wasn't just about knowledge of law. It wasn't just about taking all the knowledge that's in a lawyer's head and trying to put that in the heads of the community. There's much more to it. So there's skills, there's attributes, there's psychological aspects, there's resources. So it's a multi-dimensional concept, and we can say that more clearly now with PULS 2 and with PULS 3. That's the legal capability framework that we ran with. If you're at all interested, that's set out in full in some of the Foundation's earlier work. It might help also just to try to position legal capability in a range of other concepts. It's in a very similar ballpark to legal literacy, functional legal literacy, what some people might write about as subjective legal empowerment, legal awareness, legal consciousness. It's in the same ballpark as legal confidence, legal socialisation. And just recently, there's been some work talking about legal actuation. All of that broadly in the same ballpark. And when we look a little bit broader, it's in a similar sort of ballparks to thinking about things like literacy, numeracy, skills, self-efficacy, health literacy, functional literacy, digital literacy. So these are concepts that are widely used across other parts of social and human services. And our legal capability work really pins points into the legal aspects of it. So legal capability focuses on what people and groups need to be able to make effective use of law and the legal system if they choose to do that. And so it really helps to make sense of the differences in legal problem-solving behaviour that we observe through the research. It's also really important for explaining why some people struggle to take effective action, despite the widespread provision of legal assistance services and despite widespread access to justice reforms now for 50 plus years. People have been struggling or working on the access to justice problem now for well over 50 years. And certainly in PULS, we still see really high rates of unmet legal need. We think legal capability is really useful. So what did we do? How did we assess it? Well, we operationalised several measures of legal capability. So there were measures of knowledge, skills and confidence. 1, 2, 3, 4, just 6 measures there, 3 measures of attitudes. We also developed composite measures. Nigel may or may not go into that. But just really quickly, I'm going to take you through some of these measures this morning. The key takeaway point is just to see the distribution of the capability. That's the key point. So all of this is just going to try to build a bit of a platform for the showstopper that will come in a minute. So to measure general legal knowledge, we asked a series of questions about 5 particular areas of law: property, rental, neighbours, consumer transactions, employment and family law. Here's the distribution. Again, this is sort of, if you think about all of the measures as being a diagnostic tool, that's what's important. So this is the distribution. So overall, respondents provided correct answers to just over 70% of the questions. It did vary by area of law, but importantly, less than 20% of people answered 10 or more questions both correctly and confidently. This provides us a basis to look at how legal knowledge is distributed across the community, and that's the important bit. There was some strong social patterning of that by age, sex, main language at home, caring status, long-term illness and disability, geography, either higher or lower. I won't go into a lot of detail. If you're really interested, it's in the report. Importantly, some findings might be counterintuitive at first, but what they suggested to us that it pointed to knowledge amongst some cohorts being stronger because they had higher involvement with those areas of law, either because of the involvement or just by the necessity of being involved in those areas. Legal confidence. Again, legal confidence was measured with a series of items. The scale presents respondents with a series of increasingly demanding scenarios and asks them how confident they would be about achieving a satisfactory result in those circumstances. This is a distribution. So again, we see a smallish population, a smaller proportion, 20%, just over 20% that are in that sort of low confidence group. Roughly half the respondent population somewhere in the middle, and then again another quarter that was sort of high confidence. Again, I don't really have time to break down exactly how that varied, but it did vary by certain cohorts. So both the youngest and the oldest had the highest proportion of low confidence people and the lowest proportion of high confidence people. There are similar distributions by sex at birth, for Aboriginal and Torres Strait Islander people, main language spoken at home, family status, caring status, mental distress, income, geography. So hopefully you're getting a sense of pattern that's across all the measures. Practical legal literacy was a measure that goes towards being able to obtain, understand, use, navigate information. We tapped into that with 6 questions, and is really informed by approaches that have been taken before in health literacy. They're sort of based on the insight that health services can be wasted or actually detrimental where patients are unable to follow the instructions or the advice that is prescribed to them. Perfect example is people on their prescriptions who are unable to process and understand what the dosage of the medication and the timing that they're suggested to take. And if we stop to think about it, so much of the legal advice that we do falls into that same ballpark where if you can't understand and process the advice, it's going to be less efficacious. And so there were 6 items there. And this will just give the slide here just gives a flavour for what those measures are. So it's things with like having difficulty filling out forms or having difficulty understanding information, finding it difficult to understand what's been said to you when you're having discussions in person. So again, all of that's used to develop a scale. This is the results there. So we found about just under 1/3 of people had adequate literacy and that they didn't have any difficulties in that measure. There was a larger group in the middle of about 50% the adequacy, but they had some issues. But there was a long tail of about 18, almost 20% again. So we're getting close to that 20% figure again, which struggled with sort of marginal literacy or what we would describe as inadequate literacy. Again, that's socially patterned. It's pretty much as you might expect. So we found higher proportions of people in the inadequate literacy stratum from Aboriginal and Torres Strait Islander people, people whose main language was not English, people with a lower than Year 12 education, and people experiencing mental distress and financial distress. The perceived relevance of law measure. This was developed by Nigel in some earlier work at the Victoria Foundation through the community perceptions on law survey. That's all set out in a report. It's really based on the insight that if you don't see the law in situations, so if you don't see the legal aspects of the situations and circumstances that you're in as being relevant, you're less likely to try to use law and the justice system to resolve those situations. It's previously, we might have described that as the most obvious empirical legal needs research finding ever. It's also perhaps the most important one. So if there's one thing you walk away from today in terms of the capability, it's if you don't see and perceive the law, you don't try to use the law. Fundamental access to justice barrier. So again, the measure here, asking people about how relevant they saw the law in a series of scenarios. That's that set out there. You can check it out later. Again, what's important is the distribution. So we saw just under a quarter that had low perception of the relevance of law to many situations in their lives. About 50% of people in sort of the medium strata, and about another quarter, just over a quarter, that saw the law as being highly relevant. So this is giving a good sense that people in the community, there's a distribution as to how familiar and engaged and understanding they are with law. Again, it's socially patterned. So we see lower perceived relevance of law amongst the youngest and the oldest age groups, non-English main language, those without caring responsibilities. You might pause to think about why that would be. We can talk about that later. Those with lower educational qualifications, those living in major cities and in the regional areas, those with no long-term illness or disability. And so here again, it's no caring responsibilities here, and it's no long-term illness or disability, but it is those with severe mental distress. Maybe to give it away, it's to do with the engagement and involvement that certain cohorts have with the law. There's another measure to do with the attitudes and narratives to law. This is really going to some exploratory work around how people see the law as being relevant to them in their everyday lives. It taps into some really famous and influential work by Ewick and Sibley to do with the conceptions of legality and legal consciousness. So it's quite a famous and influential piece of qualitative research to do with legal consciousness. We took the opportunity to operationalise that. In the PULS development work, there was some survey work done, which identified that there were really 4 dominant narratives: that the law is remote, that it's arbitrary and to be resisted, that it's a practical means to obtain objectives, and there's a game to be played. Again, there's a series of questions to tap into those dimensions that's laid out here. Don't have time to cover it. Again, moving on, the findings are that most respondents, 60, just over 2/3, were more likely to say that the law was practical. There were just over half characterised law as being a game, just over 1/3 that it was remote, just under 1/3 that it was arbitrary and something to be resisted. So overall, most people tended to adhere to multiple narratives, and there were some strong relationships between those narratives, particularly those who saw the law as being both remote and to be resisted, and remote and a game. Again, it's patterned socially by age, main language, education, geography, mental distress, financial distress. A couple more just to skip through. The perceived accessibility of law scale was again developed via the Foundation's Community Perceptions of Law survey. Again, it's 10 items that ask a series of questions about how people see lawyers in Victoria, such as whether they're approachable, whether they're slow, whether they're worth it, whether they take people such as yourself seriously. Again, this is the distribution. Just under a quarter saw low inaccessibility, so the lawyers were accessible. Medium, 50%, yeah, bit some issues, but again, there is a group in the community, just under a quarter, that perceived lawyers to be highly inaccessible. Again, it's socially patterned. So those who see lawyers as being more inaccessible, older people, people with a non-English main language, single parents, de factos with children, those with lower educational achievement, those with a long-term illness or disability, again, those with severe mental distress and financial distress. By now, you've probably got a little bit of a feel that there's some recurrence around some of the cohorts in the lower or the more negative aspects of some of these measures. Moving on, trust in lawyers. So do Victorians trust lawyers? Again, 6 questions there to tap into the views about how trustworthy lawyers in the profession are. I used to do presentations where I'd open up with 50,000 lawyer jokes, can't all be wrong. And they can't all be wrong, but they're not all right either. It's because generally we find that respondents were generally very positive about the trustworthiness about lawyers. So 89% trusted them to act in the best interest, to be knowledgeable and skilled, to act ethically and within the law, not to break the rules. We start to get more of a split, 60-40 split on trusting them not to overcharge you, and another split around expecting them to exploit loopholes in the law. Again, what's important is the patterning, and we see higher trust of lawyers amongst younger people, women, non-English main language, married, without children, caring responsibilities, people not working, people with higher educational achievement, people living in outer regional and remote areas, people with lower incomes, lower trust scores amongst long-term illness or disability, again, mental distress and financial distress. Getting towards the end, there's a measure we had to do with digital legal capability. There's 8 questions there asking about experience undertaking various sorts of tasks online. Now, these we couldn't ask directly about use of the internet for law issues, given the sort of lower prevalence and the very diverse range of tools that people might have used. So we asked about analogous sets of activities and basic digital skills. So whether people had experience of and could do things like paying bills, sending an email, setting up two-factor authentication, being able to upload documents, some basic stuff. Again, what we find is a distribution across the community. So we found roughly about half the community we thought don't need any support to engage with law in the online world. About just over 20% were likely to need some minor support, but we found a cohort there of around just under 30% that were likely to need major support to engage in any serious way with legal tools and options in an online environment. Again, it's socially patterned. It's pretty much as you might predict. So those predicted to need major support included older people, those with a non-English main language, people who were not working, people with a lower than Year 12 education, those living in regional and remote areas, and people with lower incomes. Just moving on to touch on a couple of the composite measures. Here you can see all 6,008 respondents and where they scored in terms of the composite skill and attitudes measure. So overall, we see some variability. It's a straight quadrant here of positive and negative attitudes and higher and lower skills. So it's a bit of a blob, but you can see that the quadrants where people sit. Importantly, though, there are some cohorts that map into some of those dimensions more clearly. So particularly that group that we might be more concerned about, those with lower skills and more negative attitudes, included older people, those 65 plus, those with a lower than Year 12 education, those in financial distress, those with severe mental distress. So roughly what does all of this mean? Well, poor legal skills, low legal confidence, negative attitudes all limit people's ability to deal with just justiciable problems in their everyday lives, and consequently the prospects of a just resolution. Importantly, you would have seen today, nobody has perfect legal capability, but critically, some have more than others. Legal capability is not equally distributed across the community. So just like everything else we know about legal need, there's evidence of patterning, but it's not just about disadvantage. Rather, we see it as the inequality adding an additional layer, legal capability adding an additional layer of both. It can be advantage and disadvantage in ability to interact and deal with law. So overall, reasonable practical ability to engage with law for a large proportion of the community, but a sizable group with inadequate, particularly practical legal literacy, particularly that were likely to need multiple major support in relation to digital tasks, and really of particular concern are those with both low skill and confidence and those with more negative attitudes. So PULS really does show some people are likely to be reluctant to engage with the law and the legal system and face difficulties doing so, and difficulties obtaining what they need, which is me leading into you.
All right. Thank you. Thanks, Hugh. All right, well, Thanks for having me. Right, I think I can walk, I'm going to pick this up so I can walk around. That's not annoying, is it? Yeah, it's out. All right, so Hugh touched upon this idea of legal needs surveys. I thought I'd just bring you back to what they were, right? So legal need fans are probably expecting the iceberg here. I've retired it. I'm about 25 years in. I've seen enough iceberg. This is annoying. I'm putting it back. Sorry. I'm not going to do that again. Yeah, I've seen enough icebergs in the past 25 years. So we've now got a volcano. And the idea is with legal need surveys that the stuff that comes out the top, the lava, the ash cloud, I'm going to use volcano words here. That's the bit we see. That's the bit that ends up with lawyers or courts. But there's a big magma chamber below the surface that never gets up through the main vent. See, I've been learning about volcanoes. All right. So what you do with legal need surveys is you ask everyone, all right, and it allows you to go beyond the lava and capture the whole picture. So that's the general idea. Core tool worldwide to try and inform access to justice policy from the bottom up with a view to enhancing equality, accessibility of justice. It's not a new idea. So, you know, in my home jurisdiction, the UK, it's been kind of enshrined in the Constitution for the past, well, since 1215. We're still grappling with it after 800 years. But we've now got a magma carta. That's one of Hugh's. Thank you. We're here all week. All right. As Hugh said, voice of over 6,000 Victorians in their own homes, and they gave up their time to describe what for many was amongst the most difficult periods of their lives. It's data we need, and I'm hoping that this does their stories justice, and it was time well spent. All right. It's also the answer, this survey, to some things that have been troubling me over doing this since 2001. Because it's not just a legal needs survey. So we might ask, what if access to legal advice or process is not access to justice, right? It might be that, you know, getting justice, getting a fair outcome is not access to the justice system. They're not the same thing. So it's a legal needs survey that tries to operationalize what we mean by legal need, reframing access to justice in terms of just resolution. And I'll show you what that means in a second. And critically, as Hugh showed, it's a legal capability survey. And this comes from something that had been troubling us for a long time. You know, why are some people doing, taking promising paths to justice? Some people taking what look like quite unpromising routes. Why are they doing these different things or getting different things? We knew the problem type mattered. Some people said it swamped other considerations. But maybe there's more than just problems and people's characteristics. So we capture, as Hugh showed, diverse domains of capability. And volume 3 is kind of what it's all about. It's the nexus between the two. It's saying, what does legal capability tell us about what people do, what they get? All right, legal need measured. It's a horrible slide. And here's a horrible definition, all right? So it arises, legal need, whenever a deficit of capability necessitates support to enable a problem to be appropriately dealt with. It's unmet if it's inappropriately dealt with because effective legal support was not available to make good a deficit of capability. If it's unmet, there's no access to justice. That's how we defined it. These definitions aren't that helpful, though, if you can't operationalize them. So what we try and do in PULS is put the questions in place that allow us to operationalize this. So that involves questions about duration, around seriousness of problem, around legal awareness, understanding, around confidence, fairness, whether people got expert help, whether that was adequate. And what you do, you pick a path through these, and it allows you to put problems into 3 groups, all right? Whether it was no legal need, a met legal need, or unmet legal need. So this is a key advantage of PULS. It's a key thing that we weren't able to do with previous legal needs surveys that allow you to look beyond whether people used advice or used processes and think about this just resolution. So a simple example, we might have, for example, you know, moderately serious problem. Someone had legal awareness, understanding, they had legal confidence, fair process. Well, in that case, there's no legal need, right? Or we might have something that was very serious, expert help is obtained and it's adequate. Well, you've got a legal need there and it was met. Or you might have something moderately serious, we had legal awareness, understanding and confidence, but we got an unfair process and no help, right? That would be an unmet legal need. So you can see how we sort of plot our way through these different factors to put things into these 3 groups. So that's one of the core PULS concepts that we operationalize. Now, Hugh's talked a lot about this, but we also measure legal capability. There's that definition. And it's multidimensional. We can't capture it all. So we're picking off as much as we could in the survey. These are the things that Hugh talked about. So, and for the purpose of this, I'm grouping them broadly into skills and confidence and attitudes. And then we also have some composite measures. So I won't go into those because Hugh's already told you all about them. Right. For the purposes of storytelling, and this is pretty much the narrative as we see it in the survey, skills, so the stuff on the left, well, they develop incrementally, they consolidate with experience, and once mastered, they kind of endure. So those things are more likely to influence behavior around problems than be a product. Then something happens, and attitudes are susceptible to influence from life events, particularly when we've got emotion involved, as we'll see with a lot of these problems. So there's limits to causal inference, but everything in PULS is telling you, and the way I'll tell the story is that you come with skills and you leave with attitudes. All right, quick note before I get into findings. It's kind of a story about hope, right? So like I was here a while ago presenting stuff from volume 1 of PULS, and it's a pretty bleak picture, right? It's not a picture I wanted to see. It's not a picture you wanted to see. And these are the problems where there is legal need. And the majority of them, when we speak to the people, are saying our legal need was unmet. So that's bleak, but it's outweighed by hope, because in very simple terms, inequality of legal capability sits right at the heart of inequality of justice. I'll show you that capability is powerfully related to the extent in which you get what you need. So if we want to meet needs, get just resolution of problems, we need to respond. We need to acknowledge and respond to diverse capability. And it doesn't have to be hard. I'll give you some examples at the end, but it's essentially mirroring what people come through the door with the needs and capabilities that they have. Okay, some findings. So in very simple terms, this is what people do in PULS, right? So we've got, a small group of people who just don't engage in anything at all. They do nothing. We've got a bunch of people handle alone. We've got some people get informal help. We've got some independent help. We've got about 20% legal advice, roughly split between public and privately funded. And legal capability really mattered here, right? So it related to what people did when faced with problems. The strongest simple bivariate relationships we got were between practical legal literacy and strategy. Other capabilities, interesting, like the knowledge questions, knowledge of the content of the law questions that Hugh showed, had very little bearing on what people did. And then some, for example, how relevant people saw the law, which is over here, or general legal confidence remained significant even after factoring in demographics and problem types. So this is a key point. They're telling you something more than disadvantage. So Hugh's presenting a story about disadvantage, but legal capability is telling you something on top of that. So what's going on here, right? Low relevance. I see the law as less relevant, and I'm getting more legal advice. So that's interesting, right? So what's that about? Well, it doesn't mean that use of legal services means you are less likely to appreciate the relevance of law. What we're looking at here is that lesser capability increases the likelihood of seeking legal advice once this legal dimension becomes apparent. So in essence, low skills confidence here is meaning more legal advice. So face value, that's a pretty good thing, right? So lower capability people are funneling into the law once it becomes apparent that this is legal. This is attitudes though, and in general, negative attitudes are associated with more inaction, more independent help, particularly from legal services. And this is the example of people who see the law as something to resist. So if you're highly likely to see the law as something to resist, you're much more likely to get legal advice. So that's weird, right? Negative attitudes associated with legal advice. Now, this is not saying that negative attitudes drive lawyer use, right? Yeah. I see the law as something to be resisted, therefore I'll get a lawyer. What it's really telling you, it's giving you the first indication that experience of law may be driving negative attitudes, right? And at face value, that looks like a bad thing. All right, process. So legal capability mattered again. So overall, we get about 12% of our respondents end up at a court or tribunal. It's higher for those with lowest composite skills or most negative composite attitudes, right? So you can see it here, low skill, more court use, more negative attitudes, more court use. But that's only part of the story. What's really important here is about how courts are being used. And that's it here, right? So this is the percentage where court tribunal was initiated by the respondent. The other side, the rest of this would be initiated by the other side. So low skills, low confidence, negative attitudes meant much more likely to have proceedings brought against you. High skills, confidence, more positive attitudes, much more likely that you're bringing proceedings against the other side. So it's telling you that low skills confidence is a barrier to proactive court use. And there's a negative attitude cost of having the law used on you. So again, skills defining use, experience defining your attitudes. Quick bit on duration. So you'll have seen these pictures in PULS 1. But essentially, you can see at the start, all the problems exist, and then over time, they start to disappear. Right? But they disappear far more slowly for people with lower capability. So lower capability across measures related to longer duration problems, also true for composite measures. And this is a concern if we think that justice delayed is justice denied. So this is the practical legal literacy questions that Hugh showed us before. Adequate, no issues, adequate, some issues, marginal, inadequate. If we look at the people with no issues, we get around, after 5 years, about 20% of problems still ongoing. It's about 50% for inadequate. So really powerful relationships between capability and how long problems last. For attitudes, longer problems meant more negative attitudes to justice. So again, we're seeing negative experience driving negative attitudes. Right, this is the bit I like best. This is a question that we put in, and it was principally there to try and get to our measure of legal need, but it's one of those questions where it's like, why have you never asked this before? It's a really simple thing. It's basically, you can ask it for anyone, doesn't matter if they've got advice or not. We simply ask people, did you get all the expert help you needed? All right, and this is what they say. All right, so, you know, about 20% strongly agree, 40% agree, and then we've got this 40% either disagree or strongly agree. So it's a core measure of capturing legal need, but it also just does a lot on its own. It's been a really useful question. And this is why it's useful, because legal capability was absolutely pivotal here across measures. This is composite skills and confidence, right? And this is the extent to which people thought they got the expert help they needed. So lowest skills and confidence, about 8%, going up to about 50% for the highest skills and confidence. You don't often see relationships of this strength in surveys. This is incredibly powerful. And it's telling you that low skills or confidence is a powerful barrier to getting suitable assistance. Now the critical bit though. These are the people who didn't get legal advice, all right? And here we've got skills. So same picture, low skills, less likely to agree that you got the help needed. Negative attitudes, less likely to agree that you got the help needed. So skills and attitudes powerfully related to whether you got the help you needed. So what it's telling you is they're relating to your success in handling problems alone without legal advice. But that makes absolute sense, right? If you're low capability, you're going to be less able to handle alone. But here's the people who got advice. Skills and attitudes are even more powerfully related to whether you got the help you needed. So they're also relating to your success in extracting what you need from advice, from legal advice once you get it. So it's telling you, and this relationship's incredibly stable. I tried this out with, private services, publicly funded services. I tried it out with non-legal services, and you get the same picture. And it's telling you that a deficit of skills or confidence not only limits your ability to handle issues without assistance, it limits your ability to extract value from assistance. And the result is negative attitudes that on the top, which in turn are going to limit your propensity to seek services in the future. So creating a vicious cycle. Predictably, findings also extend to legal needs. So we know legal needs routine, even where advice is obtained. It's even more common for those with lower skills. Negative attitudes also strongly related to unmet need, particularly where people see lawyers as inaccessible or the law is remote. So once again, this core message, skills are defining what you get, and your experience of the law, your experience of problems is then defining your attitudes. And it goes even further. It goes on to satisfaction with outcomes or process. This is practical legal literacy, and it's telling you that inadequate literacy, far more likely to say, no, I was not at all satisfied with the outcome or how problems were progressing. And similarly for attitudes such as the extent to which lawyers are seen accessible, powerfully rated to satisfaction. So highly inaccessible lawyers related to saying, no, not at all satisfied with how things are going. So where does this all leave us? So the first thing it does is leave us with some new concepts and new potential. So we designed these surveys to operationalize legal need, legal capability. And this volume's the nexus between the two. And it kind of worked. So I've been grappling with some of these things for a long time now, and legal capability related to pretty much everything we tried to measure. It related to what you did, how long things lasted, how you accessed the justice system, and powerfully related to what you got. I didn't anticipate the power of some of the relationships we saw. And it's pointing to real potential to make a contribution to furthering of bottom-up approaches to justice. What does this mean in practice? Well, it means matching services to needs. So low levels of capability meant difficulty extracting the value from services, from the system more generally. We know that unmet legal needs routine and capabilities relating to what you get. So it's got to form part of the answer. Focusing where services are easier to provide is not going to do it for us. And we can't assume that getting people through the door of a legal service or into a process means there's no further policy or practical concerns. PULS is showing us very strongly that isn't the case. So to impart best value, the system needs to better mirror capability in order to meet diverse needs. But for now, we've got a vicious cycle. So we've seen this with justiciable problems. So we talk about, things like employment leading to loss of income, to rent arrears, to eviction, to homelessness, intersecting with health, etc. We're seeing a similar phenomenon for legal capability. So we're seeing low skills leading to unmet need, leading to poor outcomes, to negative attitudes, to becoming legally excluded. Those with lower skills, less confidence, negative attitudes are less able to handle problems alone. They get more help, but less adequate help, more unmet needs, worse outcomes. Attitudes then stem from this experience and color future interactions. So, the hope is that if we respond better to capability, we can transform some of these vicious cycles into virtuous ones. But for now, harm is being done. Those with the most negative attitudes most often receive legal assistance, but least often saw their needs met. Most often used courts or tribunals, but not as proactive litigants. So negative attitudes are not driving use. They're stemming from experience. So we're seeing a profound difference between people who are using the law and people who are having the law used on them in skills, in their experience, in their attitudes. And it has consequences. So I talk about consequences to behavior, but actually the consequences go beyond it. Negative attitudes corrode confidence in the rule of law. And doing no harm means responding to capability, because it's not a luxury. This is the social glue that binds society. This is a critical one. Hugh touched upon it. This is a story about disadvantage, but it's not just a story about disadvantage. Legal capability is linked to who you are, as Hugh showed, but it transcends those things. So I can control for all of disadvantage, everything we can think of to do with disadvantage, and still legal capability makes a big difference. And it's what that's telling you is that this matters regardless of what you come to the table with, who you are, your characteristics. We're all at risk of handling these things badly, having unmet needs and getting a poor outcome. So the imperative to respond to this stuff applies to all, regardless of who they serve. So it's an imperative to encourage appropriate levels of support. And it extends to public legal assistance, something this room would be really familiar with, but also private practice, process, and well beyond the justice sector. A lot of the findings we're seeing apply to non-legal services as much as they do to legal ones. And it's essentially a challenge in addressing capability asymmetry. I've been doing this, and Hugh's been doing this for a long time. And my official line now is that many of the inequalities in experience of problems and resolution of problems that I've been looking at for years are best understood in capability terms. They lie behind, they reinforce, they operate alongside demographic differences. Asymmetric skills lead you down vastly different paths to justice and bring about asymmetric attitudes. So taking it seriously is our route to democratizing law. It can ensure we just don't amplify advantage. And it's going to mean shifting to more human-centered approaches that can change experiences, outcomes, narratives. So how do you do this? Who should be doing it? Well, a lot of people. I'll start with this first. How do you respond? Well, one thing you might think, well, we might build knowledge, all right? One interesting thing we saw in PULS was knowledge of the content of the law. So one of the ones that Hugh showed. So whether you know what the law is in specific circumstances, had little relationship to strategy, to outcomes, to whether needs were met. And on that basis, it's not to say that community or public legal education is ineffective if you can do just-in-time interventions with bespoke groups in the right places. It's going to be highly effective. But on the basis of PULS, it's hard to make a case for broad brush public legal education focused on general knowledge. It definitely does make a case for removing barriers to entry and use. If I was to pick a single capability that was the most important in this survey, it wasn't like one of my sexy psychometric scales. It was practical legal literacy. These are the nuts and bolts of, can you read this form? Can you communicate verbally? You know, are you able to find the right person in this organization? And it was instrumental in experience and outcome. But if you look at that, right, it's generic skills. And it's no more the remit of the legal sector than it would be to like teach people to add up, right? So if you can't enhance it, it's telling you that we need to design public information, referral systems, forms, processes, interactions, expert legal services, etc. around it. Who does that? Well, obviously I'm going to say regulators nowadays, all right? I work for a regulator. But, you know, regulators set the stage for who provides different types, levels of support. They set standards, they can encourage better practice. You know, we see a lot of debate worldwide around deregulation, re-regulation, creating more alternatives. It might mean reassessing what we mean by information and advice, or finding new ways to leverage technology to safely personalize engagement and respond to capability. There's definitely a role for policymakers. They can encourage innovation, diversity of provision, tailoring form and intensity to be sensitive to needs and capabilities. It's probably going to mean more difficult or costly provision, but if we look at the vast quantity of legal need we see in PULS, it shows the imperative and incredible untapped potential. And then legal services, processors, providers, all those who directly engage with those facing problems, well, they can capture capability, they can respond, and they can collect data to respond. They can collect data to appraise the response. How do you do that? Well, maybe with really simple questions like this. So I thought I'd just show you practical legal literacy here. And you can see this is just some simple thing, you know, do you need help reading letters, brochures, etc.? This is really powerful in the survey, right? They're not the most technically flashy, but they're a powerful determinant of access to justice. You can ask questions or questions like them. You can see how people respond, and you can offer a different form or intensity of service. You can collect data to see if services are working better, and you can keep refining. If you do so, you are tailoring to legal capability, which is a step to making needs. So essentially, measure, cut to size, check the fit and do it again is tailoring to capability. Finally, where next? Well, we've done some stuff with this PULS data. If anyone likes data, the data is available and it's really easy to use. So you can download it, you can fiddle with it, you can ask your own questions. If you run into any difficulties, you can email Hugh or I and we'll help you out. So, you know, we spend a lot of time and effort collecting this stuff. We'd love to see it used, so please do use it. And then looking ahead, I'm just going to advertise what I'm doing now. This stuff doesn't stand still, so there's some stuff in PULS that bothered me now, right? So principally around, well, you know, what's going on with this relationship between capability and getting what you need? Is it specific, you know, expectations of advice that aren't being met? Is it specific things? Is it to do with, you know, intensity of service? So I've got a new survey, which I'll be reporting on in the next few months, which predictably, which captures intensity of service, gets detailed data on exactly what people were seeking, both in, you know, specific elements of service and intensity. So the extent to which they wanted things delegated, what they obtained, the difference between the two. So it's trying to give me a more nuanced understanding of what's going wrong here. There's something going wrong. Capabilities driving what you get. But we need to know more about exactly why, where we might intervene. And I think that's about me. Thank you very much. Hello.
Now you really do need to pull the microphone out of the holder. That's true, yeah, Tanya, we'll use both these. You can move it off. This side. Yeah, there you go.
I'm just standing still.
All right.
Still doing that, look. There we go.
Thank you so much, Nigel and Hugh. It feels like quite the task to try and be articulate and ask sensible questions when my brain is certainly still very much ticking over. Can we put the slide up that has the Menti QR code? And thanks to those of you who have already started to send some questions.
I'm not sure this is the most efficient way to do it. Right? It worked there.
So if you haven't already, you can link onto that QR code and you'll find a very basic slide where you can enter some questions. And that's why I'm text on questions here through that Menti survey. For those of you who haven't met me, that's probably quite a few of you, so relatively new to the Law of Justice Foundation. And I'm the research director and very grateful to have joined the team a few months ago. It really stood out so strongly in those presentations, the many intersections, right? That this is not just something about the legal sector and that broad idea of justice as being about social justice, which is important and makes it very complex as well, doesn't it? A question that I was thinking of before I move on to some of the great questions online is that when we reflect on legal capability, it's looking at the capability of the person. How do we ensure that that isn't interpreted as a call to change that person and improve their skills and knowledge and, you know, to just do more of that public legal education that you cautioned about? How do we make sure that this puts the impetus on kind of changing systems and services and not just about focusing on that individual and improving their legal capabilities?
Do you want to go? Do you want me to go? You got the mic. I've got the mic. Firstly, like, there is a role for public community legal education. There was a really nice report a few years ago, like in the UK by a guy called John Wall, who made this sort of distinction between just-in-time and just-in-case education initiatives, making the point that like just-in-case ones don't work very well and just-in-time ones work pretty well. And I've seen some really good just-in-time ones. You know, even in Law Week at the VLF, I went off to little Goldfield town, Euroa, and they were doing a wills and probate session in the library with older residents. They all turned up, they got cake. I don't know if that was the deciding factor, but you know, they wanted to know this information. They left and they applied, they left with knowledge and they applied this information, right? It was a really nice example of how you can be just in time, right? The broad message from PULS though is that like broad brush public legal education initiatives focused on knowledge are not where it's at, because knowledge just didn't really matter as much as some other things. And going to your point about how do you make a case for focusing not on raising capabilities, but on lowering the barrier of entry, I think you do that by showing that what really matters is things like practical legal literacy. You know, show me the scheme that's going to raise that quickly. It's not going to happen, you know. I mean, you can make some small inroads, but you know, that you're not going to get a lot of bang for your buck there. So it's showing that these are the things that matter, and also showing how you respond to them.
Anything to add here?
I might just add in terms of it's also brought back into focus some older ideas around it's not maybe the specific content knowledge of every area of law that people need to know, but there is a foundational aspect to knowing that there is law that gives people rights, that it might be useful to you, and that there are services available that might help you to make an informed decision as to whether that's right for you or not. We can also think of legal capability. There's a tendency to think about it in terms of individuals and to individualize a lot. You could just as easily do some really nice work to look at groups we can point to certain groups historically which have been marginalised by law and through law. And sort of we do see really, really clearly bringing back into focus where you were going to earlier in the intersection stuff with community and health services, for example, really essential, and what we knew from a long time ago in terms of they are paths to justice, they do make a difference. But the legal capability stuff really adds a deeper understanding of that. We should probably at some point be a little bit more critical about what are the more effective paths for different types of people, for different types of issues, and in different types of communities.
Thanks, Hugh and Nigel. I'll get into some of the questions that you're all posing. There's a couple actually about age. The pattern of age group, not so surprising for younger people on measures presented, but perhaps more surprising for older people. So what's your take on older people being less confident and seeing less relevance?
I guess there's a couple of older takes. Certainly the take that old people can be more resilient and be more worldly in terms of being able to judge what is a serious problem and what's worth getting a bee in a bonnet over and what isn't. So the age distribution is overlaps with issues such as that. The flip side of it can equally be true, where I'm not a parent, but I talk to parents. Parents will tell stories around how a younger person might be experiencing something and they get it completely out of whack in terms of the severity of it, but it's the end of the world. And so there's a life experience aspect that comes with some of this. And we know that legal problem experience is patterned by age, and people tend to experience different types of problems at different types of periods of their life. And it's really interesting to think about the legal capability findings with that in mind, and whether people, as they're experiencing different types of legal problems through the life course, whether they are gaining skills from that, or whether they're taking away negative attitudes.
Yeah, just on age. I mean, you can do these surveys, and I was looking at like the first of these surveys from 1938 recently, and a lot of the findings feel really contemporary. You can read it and go, oh, this feels the same. But some things do move and can move quite quickly. And the relationship between like age and what people do is one of the things that's moving quickly now. The survey I'm about to publish, Lulu, spends quite a lot of time looking in depth at, how people use different online and offline and combinations of sources, how this relates to their capability, how this relates to their age. When I first started doing these surveys, 2001, 4% of people use the internet to try and resolve their problems. It's a bit bigger now, and it's left older people behind. If I showed you the Lulu pictures, it used to be that all the narratives around older people were they have less problems, right? And if anyone ever said anything else, it would be like, oh, they handle them quite well. In the UK, they go to City and they go to Ombuds, they just walk in the door, right? They're designed for them. It's not the case now. And in age terms, there's a huge fall away now. Older people are faring worse because, new forms of service have brought new forms of marginalisation. I think this is going to be a story that I'm going to be telling for a little while now. But yeah.
We've had a question about potential intersections between trauma and legal capability. Have you considered any of those intersections, or indeed found anything in this study or other studies about those intersections?
Conceptually, yes. If you look at it's there in the discussion around legal capability in the Reshaping Legal Assistance discussion paper from 2014. So we've been looking at that for a long time. We just didn't operationalise it in those terms in this study. I mean, I think that's another important thing to be mindful of. This is just a first stab at legal capability. This was really having a go. Can we develop some measures? Do they tell us anything? Is it a worthwhile line of inquiry? This suggests this, yes, it is. Is it a complete and best measures of legal capability of all time ever? No, it's not. It's just a first step. And that there are likely to be several other aspects that we can certainly add and build in, and which may be more powerful and dominant. Nigel's highlighted the practical legal literacy measure. It may well be that there are other equally useful, if not more useful measures that we haven't had the opportunity to operationalise and test. And speaking for myself, we would welcome anybody who tried to do so.
Oh, you carry on. I don't know anything.
There was someone, and actually I had the same thought. Surprised by the data that shows regional and remote areas have more positive attitudes and higher skills than inner city areas, and one of those kind of counterintuitive findings that you mentioned, Hugh. Do you have any theories to explain that difference and that seemingly surprising outcome?
If you think about the nature of regional and rural communities in particular, I mean, in some aspects it plays into the, settler mentality, frontier spirit. Get on and deal with things yourself, used to being self-reliant, having to be self-reliant. It fits into those tropes, whether that's true or not. But yeah, it's worth considering and thinking about. But yeah, there is a distinction that I think we see increasingly between the large metropolitan areas and even between the larger inner regional areas and the more outer regional and more remote areas.
Yeah, I thought it was a really interesting finding. And the one thing I was musing on was, which I have no empirical data for, is that law probably looks quite different in those areas. If we walk outside here, what does law look like? Well, it's going to look very tall, and you're not going to get into that building. Whereas, law, if we're in a little goldfield town in Victoria, is probably called John, and he probably is on the high street. So, you may well have very different perspectives of the accessibility of law on that basis, but I have no empirical data for this.
I mean, I might just add, Jeff can tell you stories in regional New South Wales about the location of services and just how easy they are to find for some people in some places if they have those services in those places. So yeah, that's that I mentioned.
Victoria has a Charter of Rights, and that distinguishes it from other jurisdictions, including New South Wales. But what impact do you think that has played on the results and that foundational knowledge of law?
No, behave yourself.
That's a good question. Enjoy.
What's a Charter of Rights?
Look, my answer to that question, I'll step back from experiences in Canada more than 10 years ago, where despite having a lot of national effort in the Charter of Rights, it was overwhelming and really striking how they were dealing with the exact same problems that we are, same situations we are. Does the Charter make a difference? Perhaps in the foundational aspect, but I think what the legal capability stuff clearly shows is that just having knowledge in and of itself isn't enough to meet justice needs. The fact that you might have a right to something or a knowledge of what the law is on an issue, and particularly say in areas of discrimination, you still need to be confident enough to take action, to believe that it's going to make a difference, that it's going to be worth your while, and it can deliver a sensible outcome to you. And so I think the legal capability findings and that whole future line of work really points to some places where building the right types of legal infrastructure to then support the right types of behaviour and building the right types of capabilities is important.
Anything to add, Nigel?
Was there a COVID effect to the data collection, and what impact might that have had? Not had, especially in your neck of the woods.
Yeah, there was 100% there was, and because Nigel likes it so much,
So I'm the guy who thought it'd be a good idea to do a face-to-face survey in Victoria immediately before COVID kicked in. This got delayed so many times. We kept, we're all ready. We're going to go. COVID, oh, you can't go anywhere. So, we ran this survey through COVID in Victoria. As far as COVID effects with experience, response to problems, it's in the report. I don't like to talk about it. Look, I mean, we put a lot of effort into capturing it in the report in order that we could see what effect it had, but also so we could remove that effect. I honestly can't remember what it said. Like all Victorians, I've kind of removed COVID from my brain.
It's about a 2 or 3 increase in prevalence, but in fact, doing a face-to-face survey during on and off lockdown turned out to be really beneficial in terms of the problem duration findings. It really added the strength to that analysis. As a minor benefit.
Thanks, and sorry to mention the
God.
kind of Victorians. See you start to tremor.
Fieldwork discussions. They're always like, I met with the fieldwork company each week, and it's like, how many interviews have you done this week? And they're like, well, we were aiming for 400. How many have you done? 62. And it was like, that was my life for so long, because it was just so hard to do fieldwork. But we didn't want to pivot to a telephone survey because they're not that great nowadays. I think the future of these things, if I was going to guess, would be push to web surveys. That's where the world's going. Australia hasn't quite caught up yet. But yeah, face-to-face COVID.
Following on from that, do you think there are implications for a web-based survey, and what might be lost if you move to something like a web-based survey?
Okay, so 2 different ways you can do web-based surveys with this sort of thing. So you can have like a opt-in panel, so like non-probability type approach. That gets you things done very quickly and cheaply, but comes with some disadvantages regarding generalization. What most jurisdictions are putting effort in now is push to web. So essentially you have a traditional sample frame to capture people, and then you invite them onto the internet to complete the survey. But importantly, if they can't go on the internet to complete the survey, you put other measures in place. So it's kind of mixed modes, but pushing as many people as possible onto the web. And they're getting pretty good response rates around the world with those sorts of things now. And I mean, I think they hold a lot of potential, especially in jurisdictions. It's all very well in Victoria, it's reasonably contained. But as Hugh and Jeff and I have talked about at length, a large face-to-face survey across Australia comes with other fieldwork challenges, right?
So someone's made the comment that when you reported on demographic characteristics, it didn't specify Aboriginality. And can you talk about why that is and what that might mean?
Why don't you speak why I spoke about it? I can't remember it. It's Aboriginal. Aboriginal and Torres Strait Islander
Yeah.
report.
So it's there.
Yeah, it is there.
Yeah, numerically, I think we had like, we have a relatively small Aboriginal and Torres Strait Islander population in Victoria, but I think numerically it came in just over 100 respondents off the top of my head, which was about where it should have been.
It's representative.
There are a couple of questions coming through about legal practitioners and what all of this might mean in terms of their development and the ways that they work, including someone made a comment about developing emotional intelligence, for example. So what steps do you recommend, and that's casting no aspersion on any legal practitioners in the room, what steps do you recommend around educating legal practitioners on legal capability, and what are some of the practical skills, processes that you'd like legal practitioners to implement?
First.
Look, this is not my, I don't tell no one, I don't have a legal background, but
You did teach law though.
fun times. But yeah, I mean, I think it's just a recognition that, so some legal services are entirely transactional, right? But a lot of them aren't. So it's just an acknowledgement that, it's about a person, it's about their needs, it's about their capabilities, it's about, as you say, emotional intelligence. It's about, finding out about those things, about what level of support, what type of service, what form or mode of service will be appropriate in different cases and tailoring accordingly. Yeah, and what form that takes in training, I don't know, but you might have some idea.
Yeah, I mean we've done some work in a workforce survey amongst the CLC sector in Victoria, looking at the issue of what prepared them for working, what was good about their legal education, and what they felt they missed out that would have made a real difference. One of the things is just having an access to justice course available to people to be sensitized to the fact that the experience of legal claims can be very different for people throughout the entire community. That's a first basic starting point. So having education, I mean, the other thing, it's really clear in our study that the types of lawyers that end up working in public legal assistance services tended to have maybe a negative experience of law school and the experience of law schools pumping out graduates to go work for the big end of town and to pursue commercial practice. That also in our study seems to be applied into the high rates of stress and dissatisfaction with your career, where you've gone to law school perhaps for some idealized reason. Maybe it's to keep parents and family happy, and a sense that you're being pushed into a direction of a career that you don't necessarily want. And this is why we see the effect of, or for some people, working in public legal assistance can be so professionally rewarding for them because it provides a different satisfaction in terms of helping people and helping people in need and feeling that like they're making a really important difference to the community. So personally, yeah, I think there's a lot that can and should be done to prepare public assistance lawyers for the future, and everything we know about needs, intersectional needs, what's looks like it's more effective forms of service design and service provision, working in partnership, suggests that there's a number of really important things that would benefit from a slightly broader legal curriculum.
I wonder if that's one of the calls to action from this research. We are we're researchers, we kind of do our thing. But you know, some of the incredible people in this room, you know, this is kind of handing over the baton in some ways to say, what do we do with this knowledge, and how do we apply this, and you know, make meaning of this in practice and policy spaces.
And you know what, I think it's also, I mean, Hugh's got a project at the moment called Measure for Measure, which is looking specifically, and he'll describe it more, but it's looking specifically at examples where people are tailoring services to needs and capabilities. There is a lot of this, we haven't invented something brand new here. There's like a ton of this stuff going on. And, you know, when we've walked in the door, for example, of Eastern CLC in Victoria, you know, they don't necessarily use the same language, but you look at the things they're doing and they are triaging and they're tailoring to capability. So part of it, another call to arms, is to actually showcase when you've got something which is doing what you think is this, right, is tailoring to capability, and also putting things in place that allow you to measure whether it works. So, you know, that's what I would aim for.
Speaking of calls to arms, obviously, for anyone that's had involvement in the development of the new national agreement or the review of the NLAP, the idea of a national legal needs survey has been discussed. You're going to say that diplomatically, I guess. So there's a question here about whose responsibility it is to instigate a national PULS survey or something equivalent, and what could different organisational bodies do to advocate for that?
Who does it? Don't care.
Yeah.
Yeah, like, you know, I think it would be very valuable. It's not the only method in town, by the way, and there's a lot of stuff that you have to do after PULS. You know, like Hugh, Jeff, others here will talk a lot about what works, and you know, we're finding some things here, but you have to actually find out what works and then measure what works. But there's still a need and a space for a large legal needs survey. I don't care if I do it. I don't care who does it. Regarding where the money comes from, I mean, you can do cheap and expensive versions of this, right? Not everything has to cost millions of dollars. You could do a relatively cheap version if you got sick of waiting and start tomorrow. You know, I mean, I just did the Lulu one, like publish it in a couple of months. That's a legal needs survey as well. They're not hard. It's not hard. Anyway,
I'll give a slightly different answer insofar as, yeah, I think there should be a periodic investment. I think it's a worthwhile investment. We get caught up in so many issues. Like PULS fundamentally could be used in a synthetic way to model things in the country right now, if we had the time, energy and money to do so. I see the benefits of a national legal needs survey as addressing this belief amongst certain states and territories that they're somehow different. Jeff can go into the background, but this is one of the most important takeaways of the Legal Australia-wide survey, which has probably been forgotten about, is that the states and territories were all much closer and the same than people suspected that the differences were. You can go back to the issue of did a Victorian Charter of Rights make any difference in the previous Legal Australia-wide survey? Probably not. But in terms of having an investment in the infrastructure, and if we're serious about evidence-based policy, it would be a useful tool. But I'd also say that it would also be useful to make informed decisions on the basis of the findings of that work. That's where the rubber hits the road.
Thanks. We might just have one more question, and apologies to those of you whose questions we haven't got to. You might like to bail Hugh and Nigel up after the session. have you had the chance to compare the data or the findings with other countries and compare it to perhaps any global trends?
We haven't done anything directly situating the PULS data, but there's a ton of work internationally which looks at trends across the world, some of which I've done, some of which the likes of Hill in the Netherlands or World Justice Project have done, which draw out common themes, like, for example, inequality of experience, inequality of access, inequality of capability, show how these vary across jurisdictions. If you're interested in that, my stuff on that was with Pascal Pleasance, Peter Chapman, called Legal Needs Surveys and Access to Justice for OECD and Open Societies Foundation. And it tries to do exactly that. It tries to say, what are the similarities? What are the differences? What have we learned? And also critically, if we want to standardize some of the approaches to this, what are the questions we could ask to make it simple? So yes, there's a lot of work in that space. I don't think we've done it directly off PULS yet, although we do have a couple of papers coming out of it, which also draw upon specific aspects and situate them internationally.
And yeah, we probably have the most comprehensive approach and attack of the legal capability aspects. And now we're fielding questions from other places in the world and other jurisdictions as to what's been the value of doing that, and would we advise them to do that in their jurisdiction.
Legal Services Board in the UK, they put a lot of capability questions, our capability questions into their survey. So if you want to see another jurisdiction looking at some of those issues, that's probably the best place to look right now.
Great, thank you both. I might hand over to Holly to wrap up. Thanks for the incredible question. You certainly made my job easy. Over to you, Holly.
Thank you so much, Nigel and Hugh, for such a insightful session, and I think you really hit home just how crucial legal capability is in terms of getting great justice outcomes. And I think you've given us a lot of food for thought in terms of, I guess, practical examples of how we might be able to make a difference to get things a little bit better across the community. Just want to extend a very big thank you as well to HFM Judge and Tanya for hosting us in this space today, to the team, particularly Alice and Darren for putting together today's session. Thank you. And thank you to you all for taking the time to be here today. I encourage you to take up that proverbial baton in terms of, I guess, thinking about what this means in practice and how we can do better for the community. Thank you so much, and wishing you a lovely day ahead.